My name is Irene Aparicio. I'm from the Center for Civil and Political Rights, which is an NGO based here in Geneva. Thank you for joining us to talk about the situation of El Salvador, where serious human rights violations that could amount to crimes against humanity are taking place. In the panel here today, we have joining online Leonor Arteaga, who is a lawyer specializing in human rights and transitional justice and program director at the Due Process of Law Foundation, DPLF. We also have Santiago Canton, Secretary General of the International Commission of Jurists. He was previously Executive Secretary of the Inter-American Commission on Human Rights, a special rapporteur for freedom of expression of the IACHR, and Executive Director of the Human Rights Program at the Robert F. Kennedy Human Rights. We also have Antonio Guevara, lawyer specializing in international human rights law and international criminal law. He's a former member and chair of the UN Working Group on Arbitrary Detention, and he has held leadership positions in human rights organizations, government institutions, and academic settings. Lastly, we have Noah Bullock, Executive Director of Cristosal, a regional human rights organization with presence in Guatemala, Honduras, and El Salvador. And without further ado, I want to give the floor to Leonor Arteaga from DPLF, following online.
Good morning or good afternoon, everybody. We are here today to discuss the possible commission of crimes against humanity in El Salvador, a small Central American country. But where does this concern come from? Many people around the world may have heard little about El Salvador before President Nayib Bukele took office in 2019. Since then, he has gained international attention for his aggressive campaign against the country's long-standing gangs. This campaign has sharply reduced homicide rates and earned him strong support both domestically and abroad. However, this government, El Salvador government public security strategy has been implemented under what appears to be an indefinite state of exception, which has now been in place for 4 years. During this period, fundamental human rights has been suspended, and Salvadorian and international organizations have documented serious human rights violations, including torture, sexual violence, enforced disappearances, and extrajudicial executions. These reports raise a critical questions. Could these acts constitute crimes against humanity under international law? To help address this question, a group of international experts, known as HIPES by its Spanish acronym, was convened with the support of civil society organizations. This group is composed of 5 internationally recognized jurists: Susana Zacuoto, Claudia Martin, Gino Costa, Jose Antonio Guevara, and Santiago Canton, who are here with us today. Their final report, the HIPES final report, is supported by my organization, the Due Process of Law Foundation, DPLF, also the International Commission of Jurists, the International Federation for Human Rights, Interjust, and the Impactum Research Project and the Human Rights in Context program, both at Kent University in Belgium. Their investigation examined the widespread nature of these violations and the alleged involvement of state authorities in actions against the civilian population. Today, their findings and legal analysis are presented in the report that is being launched. This publication comes at a critical moment as El Salvador is increasingly referred to as a model for other governments with authoritarian tendencies. For this reason, international scrutiny and accountability are essential.
Thanks a lot, Leonor. And now I want to give the floor to Santiago Canton.
Thank you very much, Irene and Leonor. Let me start by, first of all, recognizing all the representatives, colleagues, and members of civil society. And the report we present today examines the human rights situation in El Salvador. The central conclusion of the report is very clear. There are reasonable grounds to believe that serious, widespread, and systematic violations are being committed that may amount to crimes against humanity. Some figures will help illustrate the scale of what is happening in El Salvador. More than 89,000 people have been detained under the state of emergency. President Bukele himself publicly acknowledged that at least 8,000 of those detained were innocent. As of August 25, 403 deaths in state custody had been documented, including 4 children. And by February 2025, 540 cases of enforced disappearance had been recorded. These figures are alarming, but it would be a mistake to analyze the situation only through these numbers. That's why a second central point of our report is that what is happening in El Salvador right now is not simply an extremely harsh security policy, as Bukele want the world to believe. It is a model of power that can only function by weakening or eliminating the institutional checks and balances that define the rule of law. The practices that define this model, mass detentions without evidence, the absence of due process guarantees, restrictions on access to legal defense, together with the expansion of states' punitive power, it's impossible to sustain with an independent judiciary, with an independent media, and a vibrant civil society. In other words, in a democracy. In a system where the judiciary operates as checks on power, where the press functions freely, and where oversight institutions retain their autonomy, these measures would be declared illegal or unconstitutional, but of course not in El Salvador, where the judiciary and National Assembly are de facto offices of the executive branch. In other words, when the rule of law functions, this model cannot. As you all know well, massive human rights violations rarely arise spontaneously. They require an institutional environment that enables the violations. In El Salvador, that environment was deliberately constructed on May 1st, 2021, when the Legislative Assembly summarily dismissed the magistrates of the Constitutional Chamber of the Supreme Court, as well as the Attorney General. Immediately after that, a legal reform forced the early retirement of more than 200 judges, allowing the replacement by judicial actors aligned with the executive. Once those institutional checks had been neutralized, the model advanced in other directions, like the increased stigmatization against journalists and human rights organizations, the restriction of access to public information, the implementation of surveillance mechanisms against voices critical to Bukele, and of course, civic space was weakened. Although formally presented as a temporary response to violence, the state of emergency has been repeatedly renewed and has, in practice, become a permanent form of governance. It is important to emphasize that even if this framework were really temporary, as it should be, many of these practices would still be incompatible with international human rights law. First, because several of the violations documented, such as torture, enforced disappearances, and arbitrary detentions, affect rights that cannot be suspended under any circumstances. But there is a broader issue. Many international human rights instruments, as you know very well, establish that limitations on certain rights are only permissible when they are necessary in a democratic society. This formulation is not accidental. It reflects a fundamental idea. Human rights are designed to function within a democratic institutional framework where checks on power, judicial independence, pluralism, and accountability exist. When those elements disappear and power becomes concentrated in the executive, the judiciary ceases to act as effective counterweights and civic space shrinks. From this perspective, the problem with the so-called Bukele model is not only the gravity of the violations documented, it is that it proposes a fundamental different institutional environment, one in which democratic checks and balances are weakened or eliminated as a condition for these policies to operate. In other words, and this is a third report that the report raises, the so-called Bukele model is increasingly being presented in different countries as an effective formula to combat crime. Across Latin America, several political leaders have openly expressed admiration for this approach or have proposed replicating it in their own countries. During a visit to El Salvador, current Chilean President José Antonio Cast described the country as a beacon, a model to fight organized crime that we have to follow. In Argentina, the security minister has publicly proposed adopting measures inspired by the Salvadorian model. In Peru, the mayor of Lima has defended similar policies. And during the recent presidential campaign in Ecuador, one candidate was described by the press as the Ecuadorian Bukele. They reflect the growing use of political discourse that presents the concentration of power, the erosion of institutional checks, and the suspension of guarantees as legitimate tools to combat insecurity. I know that very likely the government of El Salvador will respond by saying that we defend the criminals and don't care about the victims. I've heard that hundreds of times during my more than 3 decades of experience working on human rights. The debate is often framed as if there was an unavoidable tension between security and human rights, as if confronting organized crime required sacrificing fundamental rights. But this is in reality a false dilemma. The argument that human rights must be violated in order to guarantee security raises an unavoidable question. Security for whom? When thousands of people can be detained without evidence, when torture, enforced disappearances, and arbitrary detention become normalized, security ceases to be a right for all and becomes an arbitrary privilege by the power. In reality, human rights are not an obstacle to security. They are precisely the condition that allows security to exist without destroying freedom, justice, and human dignity. States have the obligation to combat violence and guarantee the security of their citizens, but that obligation cannot be fulfilled by committing international crimes or by dismantling the rule of law. That would be like trying to build a house by demolishing its foundation, trying to protect the people by destroying the system that protects them. Security without rights may produce immediate results, but in the long term, it erodes the very foundations of democracy and of the international human rights system, and inevitably leads to further and more serious violations. The report makes several recommendations. I will mention just only one right now because my colleague will refer to another one. And that one is the establishment of an international investigative mechanism to clarify the violations committed. Allow me to conclude with one final reflection. Crimes against humanity do not appear suddenly. They are the result of political processes in which, step by step, the institutional controls that limit power are dismantled. History offers a consistent lesson. When human rights are weakened in the name of security, what ultimately becomes weaker is security itself. Thank you.
Now I to José Antonio Guevara.
Thank you very much, Irene. Today, I would like to briefly present some of the findings reached by the International Group of Experts for the investigation of human rights violations in the context of the state of emergency in El Salvador contained in a recent report. In particular, I would like to address a central question: whether the serious human rights violations committed in El Salvador since March 2022 may constitute crimes against humanity under international criminal law. Let me start by making some methodological clarifications. This report was prepared on the basis of information produced by national and international civil society organizations, including Cristosal, the Human Rights Institute of the Central American University, Jose Simeon Cañas, the Passionist Social Service, Human Rights Watch, and Due Process of Law Foundation, among other organizations. It also draws on reports issued by the United States Department of State and Congress, the Inter-American Commission of Human Rights, and United Nations human rights bodies, as well as official statements and reporting from national and international media outlets. The report further relies on interviews conducted during our visit in San Salvador, with victims and their relatives, legal representatives, former judges, indigenous leaders, human rights defenders, political analysts, security experts, and journalists. The standard of proof applied in this report is that of reasonable basis to believe. This is the evidentiary threshold used by the Office of the Prosecutor of the International Criminal Court when assessing whether crimes under its jurisdiction may have been committed. The same standard has also been applied by independent international fact-finding mechanisms established by the Human Rights Council, including those concerning Nicaragua and Venezuela. It is important to note that the figures presented in the report are not definitive. They constitute reasonable explanations based on the information currently available. The investigation faced significant challenges due to the government opacity and the lack of complete official information, including information on deaths in custody, enforced disappearances, allegations of sexual violence, and the registry of persons deprived of liberty. For this reason, independent investigations must continue in order to clarify the full scope of the violations and determine responsibilities. The starting point of our analysis is the state of emergency declared on March 27, 2022. This measure has been presented as a temporary response to gang violence. However, over time, it has evolved into a permanent mechanism of governance. The report also highlights individual developments that enable the instrumentalization of public policy, including the illegal dismissal of judges of the Constitutional Chamber of the Supreme Court and Prosecutor General, as well as judicial reforms that force the early retirement of hundreds of judges and prosecutors, allowing the executive to appoint replacements perceived as sympathetic to the government. The state of emergency has been renewed dozens of times, resulting in the prolonged suspension of fundamental rights that cannot be suspended even in times of armed conflict. It has also involved the militarization of public security and a deep concentration of power in the executive branch, as Santiago Canton has already mentioned. In parallel, criminal procedures have been modified de jure and de facto in ways that raise serious concerns under international criminal law, including automatic pretrial detention, the lack of access to legal counsel, inadequate means to prepare a defense, the systematic ineffectiveness of habeas corpus and as a safeguard against arbitrary detention, and the introduction of anonymous or faceless judges. Within this context, the report documents the implementation of a security policy characterized by massive and consistent patterns of human rights violations. The scale of the attack is reflected in the numbers. Since the beginning of the state of emergency, as Santiago has already mentioned, more than 89,000 people have been arbitrarily detained, often without judicial warrants and individualized evidence. Approximately 7% of these arrests occurred during the first 9 months of the policy. The report documents recurrent patterns, including arbitrary arrests, prolonged incommunicado detention, beatings, electric shocks, humiliating treatment, killings, sexual violence, forced nudity, psychological violence against detainees and their families, and denial of access to food, water, and medical care of persons deprived of liberty, to name a few. These events cannot be explained as isolated incidents. They reveal a coherent pattern of state conduct, characterized by its generalized and systematic nature, carried out in the context of a state policy. Indeed, senior government government authorities, including President Nayib Bukele, have publicly defended these measures, even stating that he does not mind being called a dictator if that is the price of maintaining this policy. For this reason, the situation must be analyzed through the framework of international criminal law. According to Article 7 of the Rome Statute, crimes against humanity occur when acts such as murder, torture, arbitrary imprisonment, enforced disappearances, persecution, or other inhumane acts are committed as a widespread or systematic attack against a civilian population with knowledge of such attack. The report identifies two main patterns of attacks against the civilian population. The first concerns acts committed against individuals accused or perceived to be gang members, including severe deprivation of liberty, torture, and other inhumane treatments, deaths in custody, enforced disappearance, and sexual violence. Many of these arrests occur without individualized evidence, often based on profiling or appearance, disproportionately affecting young people from impoverished communities, including children and adolescents. For example, we include in the report a case of a young Colombian man who had migrated to El Salvador in search of safety and a better future, was suddenly deprived of liberty because of a tattoo dedicated to someone he loved deeply, his grandmother. What for him was a symbol of affection and memory was interpreted by authorities as evidence of gang affiliation. The second pattern concerns of the persecution of individuals perceived as political opponents to the government, including journalists, defense lawyers, human rights defenders, members of civil society organizations, trade unionists, and public servants. The report documents emblematic cases, such as the case of Ruth Lopez, a human rights defender, arbitrarily detained since 2024, and Alejandro Muixont, former national security advisor who suspiciously died while in custody. In both attacks, persons deprived of liberty frequently lack effective access to legal counsel and adequate means to prepare their defense, and the right to challenge the legality of detention has been systematically undermined. Based on these findings, the report examines the legal elements of crimes against humanity. First, the existence of an attack against a civilian population. Second, the widespread and systematic character of that attack. Third, the existence of a state policy reflected in the design and implementation of the state of emergency and legal reforms that weaken due process of law guarantees. The policy has also been accompanied by significant increases in the budgets of the Ministry of Defense, the Ministry of Public Security and Justice, and the General Directorate of Prisons, as well as the construction of high-security detention facilities such as the Secot prison complex. Finally, the report examines the element of knowledge. There are sufficient elements to consider that these practices were known, tolerated, promoted, and publicly defended by state authorities, as mentioned before. The conclusion is clear. Under the standard of reasonable basis to believe, the serious human rights violations documented in the report may constitute crimes against humanity under international criminal law. This raises not only the international responsibility of the state of El Salvador, but also possible individual criminal responsibility of those who designed, implemented, and tolerated these policies. We therefore call upon the state of El Salvador and the international community for restoring the rule of law, ensuring accountability, and providing reparations to victims. In particular, we urge the Human Rights Council to establish an independent fact-finding mechanism to further investigate the situation in El Salvador. We also call on states able to exercise universal jurisdiction to initiate investigations, and on states parties to the Rome Statute to consider referring the situation to the prosecutor of the International Criminal Court, as the competent authorities from El Salvador are unwilling and unable to bring perpetrators to justice. Allow me to conclude with a final reflection. Reducing violence is a legitimate aspiration of any society and an obligation of every government. but such objectives cannot be pursued at any price. When a security policy produces widespread and systematic atrocity crimes against the civilian population, the debate can no longer be framed solely in terms of public security. It becomes a matter of international criminal law, accountability, and the responsibility of the international community to protect the life, the integrity, and the human dignity of civilians, both victims of organized crime groups and of state actors, ensuring that impunity for such atrocities is prevented. Thank you.
Thank you, José Antonio. And lastly, as a voice of civil society, I will give the word to Noah Bullock.
It's particularly important and an honor to be here to talk about the situation of human rights in El Salvador under the state of exception, given the Charter of the United Nations is built on a shared conviction that the universal respect for human rights and dignity are the foundations of peace and security in the world. The findings of the report presented today describe a security model in contradiction with this core tenet of a rules-based international order, posing instead that limits implicit in human rights law on the exercise of power is an obstacle for security. It is a security model premised on the false idea that a permanent state of emergency that restricts rights, the autocratic concentration of power, are necessary to protect citizens from crime and violence. The Salvadoran government has celebrated the security outcomes of the state of exception to justify the means. To argue that the ends justify the means is a historic formula to justify atrocities that leads to societal disaster and causes damage to human lives, families that takes generations to repair. In El Salvador, the burden of this disaster and ruin is borne by tens of thousands of families who suffer and are paralyzed by the unknowing of whether their loved ones who have been captured and detained by the state are still alive, by families whose loved ones in custody were taken from their homes in good health and whose bodies were returned in sealed coffins, bearing the scars of physical abuse, the lack of adequate food and water, hygiene, and medical care. The burden is also borne disproportionately by women and families that have suffered arbitrary detentions and indefinite pretrial arrests. They become the breadwinners, the caregivers, and also the justice seekers, as fragile livelihoods are crushed by injustice. This report describes a security model that twists and distorts the responsibility of the state to protect, reinterpreting the obligations as a mandate to identify and eliminate internal enemies. The state of exception is built on a judicial philosophy of the criminal law of the enemy that poses that there are individuals and groups in a society that are such threats to the public order that they should not be protected by law. In the execution of this approach in El Salvador, there is no doubt that some citizens involved in criminal structures have been neutralized. But there are also unknown thousands of innocent citizens whose lives have been crushed in what the state calls a minimal of collateral damage. Take, for example, the young woman who was a volunteer in her community and supported women's education programs and supported activities to help her disabled neighbors. She's also one of the founders of an association of families that organized a search for their relatives that were disappeared by gangs in the early days of the Bukele regime. She was pregnant at the time of her arrest. Her pregnancy had a complication and she needed special prenatal care. The judge at her arraignment ordered pretrial detention at the request of the prosecutors and on autopilot, as is the custom under the justice system of the state of exception. She was ordered to remain in prison while her trial proceeded. Later, she won a judicial order for her release due to her health needs, but as is in custom also in the state of exception, the release order was ignored by prison authorities. She gave birth to a baby girl in prison, and after a little more than a month, the baby was released back to her sister in grave condition. The baby died days later due to a denial of adequate medical attention for the mother and for the baby itself. This woman should never have been arrested. She should never have been subjected to illegal pretrial detention. Her baby should never have been born in prison and should never have died without knowing freedom herself. In March of last year, this prison system that is the site of mass and systematic human rights violations and operates unrestrained by the rule of law was commodified and its unique services contracted out to the United States government to detain migrants at President Bukele's terrorist confinement center, Secot. Hundreds of men were arrested in the United States by immigration authorities and sent to the terror prison against court orders in the United States. They were detained indefinitely with no due process. They were disappeared into a judicial black hole. Crystal Sal and Human Rights Watch published a report in November that demonstrated that while in prison at Secot, the migrants were subjected to systematic torture and sexual abuse. We studied the background and criminal records in multiple countries of these men to determine whether they had links to gangs or violent crime. The overwhelming majority did not. The fact that these men, who were some of the highest profile prisoners in the hemisphere at the time, were tortured, the patterns of abuse that coincide with other testimonies of abuses in other prisons demonstrate the level to which torture has become state policy in the prison itself. Last week, Crystal Sal published a report on political persecution in El Salvador. We studied 245 cases of citizens that suffer both judicial and extrajudicial persecution due to their profiles as members of the political opposition, their roles as leaders in their own communities, as environmental and human rights defenders, journalists, academics, and even former allies and collaborators of the Bukele regime. What is clear in the investigation is that there is a pattern of systematic reprisals and the weaponization of the states to silence and neutralize dissent. What is also clear in the cases of judicial criminalization is that many of the measures of the state of exception, the exceptions to due process rights, for example, that were allegedly necessary to combat organized crime in the country are now used against human rights defenders like my friend and colleague Ruth Lopez, the head of our anti-corruption unit. She was arrested last May and has been in prison without trial for nearly 300 days. During the nearly entirety of this time, she has been without access to her family and legal assistance. She was held for 15 days without being presented to a judge. She's being tried in secret, similar to the cases of the state of exception, despite her request for a public trial. Her requests for release from pretrial detention for health reasons have been denied, reflecting the near universal loss of habeas corpus rights of the Salvadoran people. The Salvadoran legislature updates the number of people captured in the state of exception monthly as they celebrate and renew the state of exception in legislative decrees. The most recent number that was published indicated that over 100,000 Salvadorans have been detained and subjected to the regime of exception. After Ruth's arrest and the capture of the constitutional lawyer Enrique Anaya, these two actions, combined with the mass arrests that had already happened in the country, detonated a mass exodus of civil society leaders, human rights defenders, and journalists who rationally determined that the Salvadoran state has an unrestricted power to arrest and detain indefinitely whoever it wants, and there are no institutions in the country with sufficient independence and power to intervene to protect the rights of citizens. The regime of exception has altered the social, political, and economic behavior of the population, a population that in polls say they support the president in majorities, but similar majorities say they also fear expressing an opinion critical of him. The security environment has no doubt been altered during the state of exception. The criminal violence of gangs has been substituted by the criminal violence of an autocratic regime. When the Salvadoran people have confronted the state with evidence of these injustices in the media and in international human rights mechanisms, the institutional response has been indifference to their obligations to investigate the truth and seek justice. The primary response offered by the state in its defense is grounded in the argument that their policy is popular. If we're being honest about our past as human people, many of the regimes of mass violations have enjoyed a degree of popularity. Only in history are they judged critically. The Philippine president, for example, President Duterte, also promised that a dire security situation in his country warranted a heavy-handed security policy. Even during the reign of terror and extrajudicial killings, the regime enjoyed broad popular support. As an organization that represents victims in the criminal prosecution of war crimes and crimes against humanity from the El Salvador's armed conflict period, these people who have waited decades for justice suffered stigmatization, defamation, and denial. Impunity and indifference to human rights violations is a re-victimization that victims should not be subjected to. And it is also a choice by national authorities and the international actors. It is not inevitable. Populations across Latin America are anxious for strong state responses to crime and violence in their communities. The Salvadoran regime invests millions of dollars to popularize this model of authoritarian security across the world. But it's important to remember that strong states guarantee security while protecting rights. It is for that reason that I want to reiterate the importance of forming an international commission of inquiry into the possibility of crimes against humanity in El Salvador. In the absence of the will of the Salvadoran state to investigate impartially, the victims are being denied their right to protection, truth, and justice. People continue to be tortured and die as we speak. The data of death and torture, as I said, are live. Just since the beginning of the year, our team has documented 20 new cases of people who have died in the custody of the state, bringing that number to 420. We believe the number is most likely to be much higher. We also think that the reason that we need an investigation or an independent commission of inquiry is that the millions of people around the world who are targets of the marketing of the regime's authoritarian security model deserve to know the truth about a policy of mass and systematic human rights violations. I want to thank you all for joining us today and hope that you support us in solidarity and accompaniment with the victims to pursue truth and justice. Thank you.